We may be on the verge of one of the most consequential Supreme Court decisions in modern constitutional history. A 6-3 ruling that could permanently strike down so-called assault weapon bans across the United States. And if that happens, it won't just affect one state. It could instantly reshape firearm laws nationwide. This moment has been building for years. Since the Supreme Court decided District of Columbia v. Heller, the legal foundation for the Second Amendment has steadily evolved. Heller established that the Second Amendment protects an individual right to possess firearms, commonly used for lawful purposes like self-defense. Then came McDonald v. City of Chicago, which applied that protection to the states. But the real earthquake happened in 2022, when the court issued its ruling in New York State Rifle and Pistol Association v. Bruen. Bruen didn't just tweak Second Amendment law, it fundamentally changed how courts must evaluate gun regulations. Instead of using balancing tests like intermediate scrutiny, the court said judges must look to the text of the Constitution and the historical tradition of firearm regulation. If a modern law doesn't have a historical analog from the founding era, it doesn't survive. And that's where assault weapon bans entered dangerous territory. For decades, lower courts upheld these bans by applying interest balancing tests. They asked whether the law served an important government objective and whether it was reasonably tailored. Under that framework, bans in states like California, New York, Connecticut, Maryland, and others survived challenge after challenge. But Bruen eliminated that approach. Now, the question isn't whether a ban might reduce crime. The question is whether Americans in 1791 or 1868 had a historical tradition of banning commonly owned firearms. And that's where the constitutional pressure begins to build. Today, there are estimated 25 to 30 million AR-15 style rifles in civilian hands across America. That number dwarfs the 3.6 million estimated when Heller was decided in 2008. By any measurable standard, these firearms are in common use. And Heller was explicit. Weapons in common use for lawful purposes cannot be banned. So how have lower courts responded? With division. Some federal circuits have upheld assault weapon bans even after Bruen, arguing that these rifles are dangerous and unusual. Others have struck them down, finding no historical analog for banning an entire class of commonly owned firearms. The result is a deep and undeniable circuit split. In some states, possession of a standard AR-15 is perfectly lawful. Cross a state line and the same rifle becomes contraband. That geographic lottery is exactly the type of constitutional inconsistency the Supreme Court exists to resolve. And now the court appears ready to do just that. The possibility of a 6-3 decision is significant. The current court's composition includes 6 justices who have repeatedly signaled a strong commitment to textualism and originalism, interpretive methods that focus on the Constitution's original public meaning. In Bruen, the majority made it clear that courts cannot treat the Second Amendment as a second-class right. It cannot be subjected to tests that no other constitutional right faces. Think about it this way. The First Amendment doesn't protect only speech that is mild or widely accepted. The Fourth Amendment doesn't apply only to privacy practices popular with the majority. Constitutional rights don't depend on polling data. So if AR-15 style rifles are owned by millions for lawful purposes, home defense, sport shooting, competition, can the government permanently prohibit them? That's the central question. Supporters of assault weapon bans argue these rifles are uniquely dangerous. They point to high-profile mass shootings and claim that certain features, pistol grips, flash suppressors, adjustable stocks, make these firearms more lethal. But critics argue those features are largely ergonomic. Removing them doesn't change the basic firing mechanism. The rifle still fires one round per trigger pull, just like countless other semi-automatic firearms that remain legal nationwide. And here's the legal complication. If courts accept that cosmetic features justify banning an entire class of firearms, where does that authority end? Could legislatures prohibit any firearm that looks military style? Could they ban handguns based on magazine capacity? Could they redefine categories to sidestep constitutional protections? Bruin's historical test leaves little room for modern improvisation. The founding era did regulate firearms in certain ways, for example, restrictions on carrying weapons in sensitive places, but there is little historical evidence of outright bans on commonly possessed arms. The phrase dangerous and unusual appears in Heller, but the court described weapons that are both dangerous and unusual as outside protection. That conjunctive standard matters. Something can be dangerous, all firearms are inherently dangerous, yet still be constitutionally protected if it is in common use. And AR-15 style rifles are undeniably common. That's why many legal observers believe the Supreme Court may finally address the issue head on. A 6-3 ruling striking down assault weapon bans would likely rely on three core conclusions. First, these rifles are arms under the plain text of the Second Amendment. Second, they are in common use for lawful purposes. Third, there is no historical tradition of banning such arms. If those elements are satisfied, the bans cannot stand. The ripple effects would be enormous. States with existing assault weapon prohibitions would face immediate legal upheaval. Ongoing prosecutions could be challenged. Compliance schemes, registration systems, and feature-based restrictions might collapse overnight. But this wouldn't just be about rifles. A strong ruling could clarify how lower courts must apply Bruin moving forward. It could signal that attempts to creatively reinterpret the historical test will not survive Supreme Court scrutiny. And perhaps most significantly, it would reinforce the idea that constitutional rights are national in scope. They do not expand or contract depending on zip code. Still, nothing is guaranteed. The Supreme Court often moves cautiously. It may tailor its decision narrowly. It may focus on specific statutory language. It may remand cases back to lower courts for reconsideration under clearer guidance. But if the majority writes broadly, if they make clear that banning commonly owned semi-automatic rifles violates the Second Amendment, then the era of assault weapon prohibitions as we know them could come to an end. This is not a minor case. It is not symbolic. It is foundational, because at stake is a deeper constitutional principle. Can the government prohibit an entire class of arms that millions of Americans lawfully possess? A 6-3 ruling could answer that question once and for all. And if it does, the landscape of American gun law will change permanently. Because this case won't turn on emotion, it will turn on constitutional method. After New York State Rifle and Pistol Association versus Bruin, courts must follow a two-step inquiry, but it's very different from the old approach. Step 1, does the Second Amendment's plain text cover the conduct at issue? Step 2, if it does, the government must demonstrate that the regulation is consistent with the nation's historical tradition of firearm regulation. That's it. No balancing test, no weighing public safety against individual liberty, no interest analysis. So how does that apply to assault weapon bans? Supporters of these bans argue that AR-15 style rifles fall outside Second Amendment protection because they are dangerous and unusual. That phrase comes from District of Columbia v. Heller, where the court acknowledged that some weapons, like machine guns, could be prohibited. But here's the constitutional tension. Heller also made clear that weapons in common use for lawful purposes are protected. So the real question becomes, can something be both common and unusual at the same time? With an estimated 25 to 30 million AR-style rifles in circulation, the unusual label becomes difficult to sustain. These rifles are one of the most popular firearm platforms in the country. They're used for sport shooting, hunting in some jurisdictions, and home defense. Opponents of the bans argue that the numbers alone resolve the issue. If millions of law-abiding citizens own these firearms, they are by definition in common use. But states defending the bans attempt a different strategy. Instead of focusing purely on ownership numbers, they argue that common use should be evaluated in proportion to the population. They claim that only a small percentage of Americans own AR-15 style rifles, perhaps 6 to 8% of adults, and therefore the firearms are not commonly possessed in a constitutional sense. That argument creates a conceptual problem. The First Amendment does not protect only books read by a majority of Americans. The Fourth Amendment does not apply only to privacy practices adopted by most citizens. Constitutional protections do not hinge on popularity contests, and several justices have already expressed skepticism toward that type of proportional reasoning. Then comes the historical analysis, the heart of Bruin. States defending assault weapon bans argue that there is a long tradition of regulating especially dangerous weapons. They point to 19th century restrictions on Bowie knives, certain concealable weapons, and early machine gun regulations in the 20th century. But critics counter that those examples are not analogous. First, many of those historical regulations did not ban possession outright. They regulated carry or imposed taxes. Second, repeating firearms existed in limited form during the founding era, yet were no widespread bans on owning them. The absence of historical bans on commonly owned arms is a powerful argument under Bruin's framework. The Supreme Court in Bruin emphasized that modern regulations must be relevantly similar to historical ones. That means looking at how and why regulations burdened the right to armed self-defense. Feature-based assault weapon bans, which prohibit rifles with detachable magazines and certain characteristics like pistol grips or adjustable stocks, have no clear founding-era equivalent. There were no laws banning muskets because they had particular grips or barrel features. So states pivot to another line of reasoning. They argue that AR-15 rifles are functionally similar to military weapons and therefore fall closer to M16 rifles, which Heller suggested could be banned. But that comparison introduces technical and legal complications. The M16 is a select-fire rifle capable of automatic fire. AR-15 style rifles are semi-automatic. They fire one round per trigger pull. That mechanical distinction has constitutional significance because Heller referenced weapons most useful in military service in the context of automatic weapons. Lower courts are split on whether that language allows bans on semi-automatic rifles that resemble military designs. Some circuits interpret it broadly, upholding bans on the theory that these rifles share characteristics with military arms. Others interpret it narrowly, focusing on firing mechanism rather than appearance. This disagreement is one reason the Supreme Court may intervene. Then there's the question of magazine capacity. Many assault weapon bans are intertwined with limits on magazines holding more than 10 rounds. Here again, the Bruin framework creates difficulties for states. Magazine capacity limits did not exist in the founding era because firearms technology was different. Multi-shot firearms were rare but not unknown, yet there is no clear historical tradition of limiting the number of rounds a law-abiding citizen could possess in a single firearm. States attempt to construct analogs by citing regulations on gunpowder storage or restrictions on carrying certain weapons in crowded places, but critics argue those analogs address different risks and impose different burdens. The Supreme Court will have to decide how close the historical match must be. Does the absence of a precise founding-era analog doom modern bans, or can courts extrapolate broader principles from history? The majority in Bruin appeared to reject open-ended extrapolation. They emphasized that courts must look for historical regulations addressing similar societal problems with similar burdens, and that requirement places modern assault weapon bans on uncertain ground. Another key issue is the standard of review for facial versus as-applied challenges. If the court strikes down an assault weapon ban facially, it would invalidate the law in its entirety. If it rules more narrowly, it could allow certain restrictions while prohibiting broad categorical bans. The tone of the majority opinion will matter. A sweeping opinion could clarify once and for all that banning an entire class of commonly owned semi-automatic rifles violates the Second Amendment. A narrower ruling might focus on specific statutory definitions or procedural defects. Given the court's current composition, many observers believe at least 5 justices, possibly 6, are prepared to apply Bruin rigorously. In Bruin itself, the majority signaled frustration with lower courts that treated the Second Amendment differently from other constitutional rights. That sentiment could resurface here. If the court concludes that lower courts have effectively reintroduced balancing tests under different names, it may issue a firm correction. And that's where the 6-3 dynamic becomes crucial. A strong majority opinion, joined by 6 justices, would send an unmistakable message to lower courts nationwide. It would not merely resolve one case, it would establish a durable rule. But the dissent will likely warn of public safety consequences, citing mass shootings and the perceived lethality of these firearms. The dissenting justices may argue that the Constitution allows democratic experimentation at the state level. The majority, however, will likely respond that constitutional rights do not fluctuate with legislative preferences. That philosophical divide have defined recent Second Amendment jurisprudence. This would not be a symbolic ruling, it would be structural, because once the court applies the framework established in New York State Rifle and Pistol Association v. Bruin to semi-automatic rifle bans, the precedent would ripple through every pending Second Amendment case in the country. Let's walk through what would likely happen next. First, states with existing assault weapon bans would face instant legal consequences. California, New York, New Jersey, Connecticut, Maryland, Illinois, and others have statutes that prohibit the sale and, in some cases, possession of rifles defined by features like detachable magazines combined with pistol grips, adjustable stocks, flash suppressors, or threaded barrels. If the Supreme Court declares those bans unconstitutional, enforcement would effectively stop. Ongoing prosecutions could collapse. Convictions could be challenged. Registration schemes might become legally void. And state legislatures would have to decide whether to attempt narrower regulations or abandon the category altogether. Second, the decision would likely affect magazine capacity limits. Even if the court's opinion formally addresses rifle bans, the reasoning would almost certainly apply to standard capacity magazine restrictions as well. If the majority concludes that commonly owned firearms cannot be banned because they are in common use, the same logic applies to magazines owned in the tens or hundreds of millions. Lower courts would be forced to reconsider prior rulings, upholding 10-round limits under now invalidated reasoning. Third, this ruling would fundamentally change the litigation landscape. For years after District of Columbia versus Heller, lower courts often upheld gun regulations by applying intermediate scrutiny, even when they claimed to be following precedent. That era effectively ended with Bruin, but many lower courts have continued to interpret Bruin narrowly. A firm 6-3 ruling invalidating assault weapon bans would remove ambiguity. It would signal that the court expects strict adherence to the text and history standard. It would discourage creative reinterpretations designed to preserve pre-Bruin outcomes. That message matters. Because the Supreme Court rarely takes Second Amendment cases, when it does, its opinions shape doctrine for years, sometimes decades. Fourth, the ruling would reignite the national political debate. Supporters of gun control would likely push for federal legislation. There could be renewed calls in Congress to enact nationwide restrictions, but any federal ban would immediately face constitutional challenge under the same precedent. The legislative path would become dramatically narrower. Meanwhile, Second Amendment advocates would likely frame the ruling as confirmation that the right to keep and bear arms is not a second-class liberty. And this raises a broader constitutional question. What does it mean for a right to be national? The Supreme Court has long maintained that constitutional protections apply uniformly across states. The First Amendment does not function differently in California than it does in Texas. The Fourth Amendment does not fluctuate between New York and Florida. Yet, in practice, firearm laws have varied dramatically based on geography. If assault weapon bans are struck down nationwide, that geographic disparity would shrink. The baseline of permissible regulation would become more consistent. But consistency does not mean deregulation. States would still retain authority to regulate firearms in sensitive places, schools, courthouses, government buildings. They could enforce background checks, licensing requirements, and prohibitions on possession by felons or those adjudicated mentally ill. What they could not do, if the court rules broadly, is ban an entire class of commonly owned semi-automatic rifles. That distinction is crucial. The majority opinion would likely emphasize that the Constitution allows regulation but not prohibition of protected arms. There is also the question of retroactivity. If individuals were convicted under assault weapon bans later declared unconstitutional, courts would need to determine whether those convictions can be vacated. The answer would depend on procedural posture and retroactivity doctrine, but legal challenges would certainly follow. Additionally, manufacturers and retailers would face a transformed market. Companies that avoided certain states due to restrictive laws could re-enter. Compliance costs would decrease. Product standardization across state lines would become easier. But with that change would come renewed scrutiny from policymakers, advocacy groups, and the media. And beyond rifles, the ruling would set precedent for future disputes over emerging technologies. The analytical framework established in this decision would guide how courts approach those controversies. If the court draws a bright line around common use, litigants will focus heavily on ownership data in future cases. If the court defines dangerous and unusual narrowly, that phrase will carry less regulatory weight moving forward. Perhaps most importantly, a 6-3 decision would represent institutional continuity. From Heller to McDonald to Bruin, the Supreme Court has gradually expanded and clarified the Second Amendment's protections. A ruling invalidating assault weapon bans would be seen as the logical extension of that trajectory. But it would also test the court's relationship with lower courts. In recent years, some justices have expressed frustration that certain lower courts appear resistant to applying Bruin as written. A strong majority opinion could serve as both clarification and correction. Whether lower courts adjust immediately or attempt narrower interpretations would determine how smooth the transition becomes. And then there's the cultural dimension. Firearm regulation is not just a legal issue, it is deeply tied to American identity, federalism, and competing visions of public safety. A sweeping decision will not end that debate. It may intensify it. But from a constitutional standpoint, the question before the court is narrower than the political rhetoric suggests. It is not whether assault weapon bans are wise policy. It is not whether legislators believe such bans promote safety. It is whether the Constitution permits them. That is a fundamental transformation. And that is why this potential 6-3 ruling matters so much. Because once the Supreme Court establishes that an entire category of arms is constitutionally protected, reversing that principle would require either a dramatic shift in court composition or a constitutional amendment. In other words, the impact would not be temporary. It would be enduring. The coming decision could mark the moment when assault weapon bans as a legal strategy reach their constitutional limit. And if that happens, American gun law will enter a new chapter, one defined less by patchwork prohibitions and more by a uniform constitutional baseline. Whether one sees that as restoration or upheaval depends on perspective, but there is little doubt about the magnitude. A 6-3 ruling striking down assault weapon bans nationwide would not simply resolve a circuit split, it would permanently redraw the boundaries of the Second Amendment in the United States.